I just pressed the Let's Go Live button, which means you know the routine. We've got to wait for the stream to fire up all across the fruited plain of the internet. Before we go ahead and get started, got to make sure the tubes are working. Sometimes the tubes, they think they're still in 2023. Is it time to go back to work? Yeah, it's time. And actually get rid of those tubes and bring the new tubes in here. It's fresh new year. We want fresh tubes in the house. And it looks like we're alive on the YouTubes. Looks like things are coming in okay over on the Rumbles. We've got locals firing up here any minute. And then we're going to be able to go ahead and get started as soon as I see that little screen flip over there. Usually happens by now. Aha. There it is. Over on the locals. Good news. Okay, so that means we can go ahead and get started. So let's do it, shall we? Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live, the show that spotlights misconduct involving police, prosecutors, and politicians. My name is Robert Gouveia. I am a criminal defense attorney, and today we're talking about Donald Trump's immunity and the appeal that is taking place out of the D.C. Circuit Court of Appeals. We're going to go through it in some detail today because this is a major issue. This is a historic issue, something that is going to be anchored in the law school textbooks and political jurisprudence for all the future. I mean, is the president immune or not? Is the president somebody who can get prosecuted by illegitimate political appointees like Jack Smith? Is that allowed in America? The courts are going to have to decide this. And so we know that this is already being used to take out Trump, but is this going to just be part of the new operations of American law? We're going to get into it. Donald Trump submitted his reply brief yesterday on the show. We read through Jack Smith's response. So the response was against Trump's original appeal, and this is Trump's final word. We'll read through it, unpack what is inside before we go around and check in with the White House. The Biden spokespeople are saying Donald Trump is a threat to democracy, an existential threat to democracy. And that is, of course, something that we've been hearing a lot of here. Weissmann, who has a podcast that is dedicated to Trump, is saying what happens if the Supreme Court rejects this case and the status quo remains. That would be a big problem for Trump. And then lastly, Christina Bobb, one of Trump's attorneys, will be out here and communicating accordingly. And then we've got our second segment, which is a second filing from our friend Edwin Meese, the Attorney General under Ronald Reagan. No longer the Attorney General, former obviously, but he submitted an amicus brief to the United States Supreme Court. We are not at the Supreme Court right now because Jack Smith got rejected when he was trying to leapfrog the Court of Appeals. And so Ed Meese and the law professors, they submitted a filing up to the United States Court of Appeals because that's where we are at the current moment. And we're going to be seeing what is inside that filing because, as we know, Ed Meese says Jack Smith is illegitimate. He was not properly appointed by the president, confirmed by the Senate, and the entire special counsel facade is a giant joke. So we're going to go through that and see what is inside. Liz Cheney, wild. She says, Donald Trump, he might come in and be the person who actually appoints people who are unconfirmed loyalists to him. Says that he might just say, throw somebody right in the Senate, and Senate not even confirming him, and this would just wreck the country. And we're going, hey, Liz, hello. That's what your side is doing right now, like literally. Hello, wake up, Liz. So we're going to go through that. And then in our final segment, we're going to turn our attention over to Maine because Donald Trump has filed a lawsuit, a petition in the Superior Court of Maine for review. He's saying, look, courts, actual judges, actual attorneys here who actually, know what the hell they're talking about. Can you please review this weirdo's opinion who said that we got to save American democracy by disenfranchising the entire state? Well, we're going to go through that. It's a short suit, just basically asking the court for review. We'll hear from Shenna Bellows. We'll hear from Raskin. And then, of course, the question is there any backlash to this type of removal? Is it a problem that they're disenfranchising American citizens who want to vote for their particular candidate Is that a problem? We're going to hear what Joe Scarborough misses, what she has to say, Mika. And then even CNN is admitting, we've never seen anything quite like this, right? They're looking around and they asked their guest, Jake Tapper was over there. He says, well, what do you think? He's like, well, I think it's a disaster. Oh, well, me too. What do you think? Like, I think it's a disaster too. And every time this happens, it feels like the other side goes up in the polls. Then we'll have James Comer, who's out, and he's going to be explaining that this is clearly election interference. This is not anything that we have not been saying here. We've been saying it since day one. Ever since the FBI raided Melania's closet, we know that that was election interference by the intelligence agencies. Okay, that was it, day one. They went and gobbled up classified documents that they probably didn't want Trump to have. And so this has been going on for quite some time, but we're glad to see a lot of people talking about it now. So as you can see, my beautiful friends, we've got a lot to get to today. We've got 3 juicy segments, and we are excited to unpack them. We've got our members only stream this morning. We talked about Biden launching his new insurrection propaganda tour. So we'll have that video coming out later as well. For members, we do members only streams in the morning. We already did a great stream this morning. We had a lot of fun. In fact, I think we're going to try to solve the debt crisis in America. Very complicated math equations happening there, but I think we can probably figure it out. But the point is, Joe Biden is going to be going around on the anniversary of January 6th. So if you haven't gotten your confetti out for the Insurrection Day, which is coming up just a few short days from now, get ready. Okay, get your whatever insurrection gear we have. I don't know. We'll have to ask the FBI. Maybe Ray Epps can tell us. So we had a great members only stream this morning, watchingthewatchers.locals.com. That's the place to go and join us. We do Saturday streams, and we got some other fun stuff cooking over there. We also have our website, robertgovea.com, where if you want to get any of the PDFs that we review here, that's the place to go. We also have our newsletter, so you can sign up for our newsletter. Get the daily show reports delivered to your inbox every day, and that way you don't miss a thing. And then, of course, there is still time to join our Watcher Lodge Fitness Challenge. And the Lodge is our newest project, and we're warming it up. We're learning how to use the platform and how to engage with everybody by doing a fitness challenge. And we're going to be really talking about sovereignty and self-development at the Lodge. I got a whole bunch of plans for 2024 that we're going to be discussing together, and so very excited about it. But right now, we're doing a fitness challenge, and you can win prizes. You can still sign up between now and Friday. There's a fitness thread over there. Get your reports in if you're already joining it. We've got prizes coming out. We got Lodge scholarships that are going to be given away. We're going to give away some gear. We're going to give away some good stuff. And so this is what it looks like at the Watcher Lodge. You can go here. You can see I posted my day 3 update, which is right here. I was at the gym today. We did a little bench and triceps today, a little bit of a push day. Yesterday, what the heck did I do yesterday? Legs. Oh, yeah, yesterday was a leg day. So we had that. So that's watcherlodge.com. Go and check it out. And you have to have Friday to join us for the challenge to be eligible for the goodies. Okay, so now let's get into it, my friends, because we've got some historic case briefing to attend to, talking about presidential immunity all across America for the foreseeable future. So let's just do it. Donald Trump slams Jack Smith's attempts to destroy presidential immunity before it's even established. We know Donald Trump has been appealing this case that came out of Judge Chutkan's courtroom. Trump said, hey, you can't prosecute me and indict me for stuff that is within my job description as the president. If I'm out there speaking about a rigged election, then that's my job, because the executive doesn't want rigged elections to take place. Well, we know Judge Chutkan out of D.C., she says, well, if we do that, America's going to die. And she said, sorry, Trump, your case does not get dismissed. So Trump submitted an appeal on this. And that's where we're currently at. Now, remember, for context, Jack Smith wanted to accelerate this appeal. And he also wanted to leapfrog this appeal by taking it to the Supreme Court of the United States. Supreme Court said, nah, there's no rush here. Why don't you just go on back down through the regular Court of Appeals and respond there? So on a prior video, we already reviewed Jack Smith's response to Trump. Trump said, I'm appealing because I've got immunity and double jeopardy, the two main issues. Jack Smith responded and said, if we give you that, then we're all going to die, because Donald Trump literally could just execute Congress. That was in his motion, not my words. The president could just execute Congress and then they wouldn't impeach him and stuff like that. Kind of psychopath stuff, but we're talking about Jack Smith. And so now this is Trump's final word. This is at the Court of Appeals. And this is the final layer of the sandwich before we get oral arguments, which are going to be taking place about 1 week from today. We'll be covering it, of course. Thank you for subscribing to join us on that. But now this is Trump's final word before those oral arguments. It's 41 pages. We're going to hit the highlights. Case is United States of America versus Donald Trump on appeal. This is the reply brief from Trump out of the D.C. Circuit Court of Appeals on appeal from Chutkan's courtroom. Oral arguments scheduled. Mark those calendars for January 9th. And then this will be something that is going to be appealed going up to the Supreme Court. So we're making a record, and this will be a historic case. We know who the parties are. We've been covering this case for a while. We already know that what the table of contents includes: a bunch of brilliance from Trump's defense, and so on. And as we fast forward through all of this, we get right into the summary of the argument from Trump's defense. They say, "Dear Court of Appeals, President Trump has immunity from prosecution for his official acts." And we're always comparing and contrasting these framings because Jack Smith says Donald Trump is arguing about about absolute immunity, so that he can just do whatever he wants and, it's kind of a free-for-all, which was never Trump's argument. It was always much more circumscribed. They say, under our system of separation of powers, the executive power, the presidency, is exclusively vested in the president. Now, a president's official acts can, quote, never be examinable by the courts. That came back from a seminal case in American jurisprudence called Marbury versus Madison. Arguably the most important case in American law. 1803. Because if this happened, if this case were decided that the courts can say that a president's act is examinable, then doesn't that make the court really the president? So it established this real interesting line that, oftentimes I think a lot of self-interested men at the time would not do. They want to give themselves more power, and that didn't happen here. So it's a very seminal case. That's why it's so important. Now we don't have any of that. Now we just have one political person prosecuting his enemy. So they say the judicial branch cannot issue equitable relief directly against the president's official act. So the court can't order something against the president, including his power under the take care clause. In other words, the president has an obligation to his duties. So also it cannot sit in criminal judgment over them. So it's an extension of Marbury versus Madison. If the court can't examine the executive, then how can the court, through criminal law, now suddenly examine them? Because they just decided that president's conduct was criminal. Because Jack Smith and Joe Biden ordered Merrick Garland to go get this done. So that they say the Constitution's text and history and policy support this conclusion. The impeachment judgment clause presupposes the existence of presidential criminal immunity. It's obvious. Early commentators, including Alexander Hamilton, James Madison, Chief Justice Marshall, Justice Story, ever heard of them? They support it. And they're supported by the 234-year unbroken tradition of not prosecuting presidents for official acts, despite vociferous calls to do so from across the political spectrum. Also provides powerful evidence of this. In the last 234 years, we didn't have anybody demented enough to do this because it wrecks everything. Now, analogous immunity doctrines, also rooted in the separation of powers, demonstrate the basis and the existence of criminal immunity for presidents. The likelihood of mushrooming politically motivated prosecutions, you mean like 4 of them? Yeah, probably like the ones we have like right now. Yeah. And future cycles of recrimination are far more menacing and crippling to the presidency than the threat of civil liability. And remember, we've already talked about this Nixon case. We've already established in the Supreme Court that there is presidential immunity for civil liability. So they're saying if that's obviously something that's necessary to protect against that, this is obviously the next extension. Therefore, the scope of criminal immunity has to be at least as broad as civil immunity. For example, in other words, the outer perimeter of the president's official responsibilities. He can go all the way to the maximum wingspan. He can capture it all in there. All 5 classes of conduct from Jack Smith in his indictment, everything that he put in the document that he says, this is criminal, all falls within the scope of the perimeter. Saying the impeachment judgment clause and principles of double jeopardy, they both independently on their own bar Jack Smith from bringing this prosecution. And the plain text of the clause, ordinary principles of interpretation, the decisive weight of the historical evidence, they all confirm that a president who was impeached and acquitted is not subject to additional prosecutions by deranged thugs. They say here, Court of Appeals, now the government came to you with their so-called statement of the case, which we read through. And they say that the government's statement of facts is both legally and factually incorrect. F. Thanks, Jack. F minus. Try it again. Now, the government attempts to emphasize the allegedly unlawful manner and purpose of the acts alleged in the indictment. But however, assessing whether immunity applies, that's not what the courts do. The courts must look to the nature of the act itself. So Jack Smith is applying a different test. The improper manner or purpose is just not relevant under the law. Even worse, they say, so Jack Smith is picking a wrong test and he's trying to apply the wrong test because he's deranged. But even worse, the government relies on facts that are even outside of the indictment. Okay, the 4 corners of the documents, they all allege criminal conduct. That's what we charge on. If you want to say somebody's guilty of something, you got to put it in there so that we can know about it, so that we can get evidence about it, so that we can present our defenses to it, and so we can ask the jury to issue an opinion on this, guilty or not guilty on that one. So when you start bringing in a bunch of other stuff, you say like this person caused an insurrection, but you know, he also leaves the seat up at home too. Also, he does that too. And there was this one time when he didn't hold the door open for somebody, and he's kind of a jerk because he's, whatever, like all of these other things, all irrelevant. It's all meaningless. Get out of here. You don't get to say all that stuff. Like, what can you prove? This is a court of law, not The View. All right. Here, even worse, they say they're using a bunch of stuff outside of the 4 corners to wrongfully suggest that Trump is responsible for the events at the Capitol. But they didn't charge him for those things. They say this is improper. The indictment does not charge President Trump with responsibility for the events at the Capitol, like literally. So that's a fun statement, right? They're not even blaming him for the riots at the Capitol, is what Trump's defense is saying. Doesn't even charge him for that because these are like conspiracy to obstruct. Donald Trump talked with the DOJ. Conspiracy. Donald Trump talked to Mike Pence. Conspiracy. He talked to the alternative electors and all, alternate electors, blah, blah, all the things. But they're not even charging him with the J6 stuff. And so no evidence supports those allegations. Now, the government's account selectively omits key facts in their little narrative, such as this one. For example, in his speech at the Ellipse, President Trump encouraged the crowd to, quote, peacefully and patriotically make your voices heard. They left that one out. He also said, we want you to cheer on our brave senators and congressmen and women. And they left that one out. But I think that's coded language. That actually means execute Order 66. So President Trump denounced the destruction of the monuments and other symbols of American democracy. He never encouraged anyone to enter the Capitol. He said on social media that the protesters should remain peaceful and to, quote, stay peaceful. He released a video from the Rose Garden telling protesters to go home now. And the government's brief omits the vigorous disputes and the questions about the actual outcome of the election. Disputes that date back to November 2020 and continue to this day in our nation's political discourse. And more of the country is agreeing with us. It's trending our direction because people are asking themselves about this. Wait a minute. They said that that the Russians were responsible for that Hunter laptop. I thought Putin was responsible for that. And now Hunter Biden is taking a dookie right on the steps of Congress in front of James Comer saying, I'm innocent of everything. I said, wait a minute, what? So is there something there or is there not there, right? We're asking ourselves all. So they covered up the dirty baggage for their political opponent. And then people are realizing it. Okay, the facade is crumbling off. We all see the Biden crime family is corrupt and the media covered for them. The CIA covered for them. So they're based on extensive information of widespread fraud and irregularities. Yeah, like the CIA and like the FBI, Elvis Chan, submitting reports to have channels censored. So they say, look, Trump, he said all of that, and all of that got ignored because Jack Smith doesn't care. Now, they say President Trump, by the way, has immunity from prosecution for his official acts. This is in the reply to the Court of Appeals. They say Article 2, Section 1 vests the executive power exclusively in the President of the United States. No prosecutor nor judge or jury may sit in judgment over the president's official acts, because that would be insane, because then that person would be the president. And every time that we say, well, the classified documents are not Trump's. I mean, wait a minute. So Congress can just pass some statute somewhere that says that these are classified documents? That doesn't override the president's power under the Constitution that's delegated to him. Otherwise, and if they could, then that makes them more powerful than the president. That makes the FBI more powerful than the president or NARA. If Donald Trump has to fill out a form for Deborah, hey, Deb, can I have my documents? No, get out of here. What? Okay. Thanks, President Deb. It's ridiculous. Same thing here. A president's official acts can never be examinable by the court. And when Liz Cheney was crying from her podium up there, whining about Trump should have done something else, that's not her prerogative. She doesn't get to substitute her judgment. She's not the president, never will be. She's not even in Congress anymore. Womp womp. So the government, they say, this is Jack Smith, they argue, they want to shatter like this historical precedent. They say, oh no, Marbury, seminal case, they say, it addressed the reviewability of acts of executive officers in general, but not the president in particular. So the president is excluded from that case. Now, Marbury distinguished an executive officer's ministerial duties from the president's officials act. So they say, by the Constitution of the United States, the president is invested with certain important political powers from Marbury, in the exercise of which he is to use his own discretion and is accountable only to his country in his political character. And this is the point that the left fails to get. If the country really thinks that Donald Trump is an insurrectionist, we can just vote against him. Maybe they will. Okay, we're all going to go to the polls. Probably going to be him versus Biden. Maybe, I don't know. And when we get there, people can vote. And so if Liz Cheney and Adam Kinzinger have the better argument, great, then Trump will be held accountable by the people. But we don't shatter the country and openly allow criminal prosecutions against your political opponent to save the country. Like, we get that. The people are the ultimate check. Now, there exists and can exist no power to control that discretion. Being entrusted to the executive, the decision of the executive is conclusive. A subordinate officer is to conform precisely to the will of the president, and the acts of such an officer as an officer can never be examinable by the courts. Marbury. And it really, you kind of set the entire tone of our jurisprudence. Jack Smith doesn't like it. Thus, the official acts of the president in italics, says Trump's team, can never be examinable by the courts. Why? Because the executive power is vested with him by the Constitution. Chief Justice Marshall emphasized that point in Marbury, says nothing can be more perfectly clear than that. The president's acts are only politically examinable. And this is why I say that the president is like the root. The president is like the origin source of total power, because that's how the system functions. The logic of the system requires it to function that way. Otherwise, somebody else is more powerful than the president, even if it is some disgusting bureaucracy. So we can't do that. It's by design. That's why it's an important and powerful position. Likewise, Justice Story also wrote about this. He said the president in his official acts is accountable only to his country and to his own conscience. His decision in relation to these powers is subject to no control, and his discretion when exercised is conclusive. Discretion. Like, this is all official duty stuff, right? Nobody's saying he can just like start nuking cities or something. So it says he reinforces this point. It is no answer that such a power may be abused. This is what they said. Oh my gosh, well, if that's true, then the president can abuse his power. Okay, that's true, writes this smart judge. Justice Story. He says, yeah, there is no power which is not susceptible to abuse. And this is where demented Jack Smith went a little bit extra demented, even for our liking here. He was saying Trump could just execute like half of Congress. Okay, look, maybe in your deluded state, but that's, yes, everything can go. You can pull on every string until it snaps. But that doesn't mean you just get to prosecute anybody on a whim because your side hates the other person. Now, the remedy for this, writes Justice Story, is to be found in the Constitution itself. It explains clearly, he writes, impeachment and Senate trial. Very easy. Somebody, if there really is a big problem with the president, boom, impeach him and have him tried very quickly. They did it pretty quick with Trump. Justice Story rejected the notion that the legality of the orders of the president would depend not on his own judgment, but on the findings of facts upon the proof submitted to a jury. Right. Yeah. So the president, I don't know if this was a good decision or not. Let's take it to court. And then we can let a jury decide whether that was criminal or not. I had to decide what to do right then and there. No, we don't run the country via criminal jury or Jack Smith. So they continued. They say, look, we're going to support this. Accordingly, we've got Mississippi versus Johnson. That says that courts may not issue an injunction against the president's official acts. The separation of powers says accordingly. And the government cites this case, but that case is inapplicable. Not even on point. The government also cites the president's amenability to criminal subpoenas as evidence. Okay, they want this. They're saying, okay, look, the president can respond to criminal subpoenas for evidence. Evidence. But Fitzgerald distinguished that. A criminal prosecution is far more intrusive because it exposes the president to liability himself. And if you want more evidence of this from our founding days, there was a convention when James Madison was there. And these were made in support of a motion to make the president impeachable for offenses in office. Impeachment, okay, from Madison, not criminal prosecution. Says James Madison, many people say he's the father of the Constitution, kind of the major thinker and crafter of it, provides a principal check against the alleged presidential malfeasance. There it is, very clear. Impeachment, not criminal prosecution. Now, contrary to Jack Smith, the threat of future prosecution with its more severe stigma and penalties is even far more menacing than a civil lawsuit. The government says the president already faces this concern, but on the contrary, impeachment and conviction. Yeah, so here Jack says, the impeachment judgment clause authorizes prosecution after impeachment and Senate conviction. Now on the contrary, they say, no, on impeachment and conviction, it requires a broad consensus of senators and representatives across the country. It provides a powerful structural check against politically motivated prosecutions, which I couldn't agree more. If Trump had done something actually bad, and he was actually guilty of this, of anything, or any president was, then both parties would say, okay, like that's enough. In American history, and you can take a look at, for example, George Santos. Maybe that's a good recent example. In American history, now, what's not a good example of that is Menendez, who also looks like maybe he's going through the process. Everybody's innocent until proven guilty. But, we'll see. We'll see what happens to him. We'll see what the Democrats do with him. Of course, they cover for their own. But in American history, 3 presidents have been impeached and none convicted. None. Stripping away this check would radically diminish the president's independence, and people would come up with newfangled and artificial treasons by which violent factions would wreak havoc and turn their malignity upon another. Written by James Madison, Federalist 47. So they say the government is now citing OLC memos and other things. And they argue that the prospect of future criminal prosecution for knowingly criminal acts can have a salutary, not a chilling effect. Now, they rely on the presumption. They say, ironically, the government relies on the presumption of prosecutorial regularity. But the prosecution of a president is necessarily and unavoidably political. So you can't just say it's like a regular criminal prosecution. Even the OLC is saying, if you're going to prosecute a president, it's going to be political, obviously, because we're not idiots. But Chutkan comes in and says, I didn't want to talk about the election. I don't care about politics. You're going to treat him like every other J6er. And those weren't political either, even though, of course, we know they were. So they say Jack Smith says that Article 3 courts, and we read this and we laughed about this yesterday, hysterical. He says, you know, if a president is being unlawfully prosecuted, the Article 3 courts can just fix it. Like they won't let politicized prosecutions come through. Oh, gosh. Hey, Jack, have you been to D.C.? And we made the mathematical arguments. What's the percent? What's the conviction rate for J6ers versus the DC local crime contingent? What's the difference? Both happen in Washington, D.C. Is it 99% for J6ers get convicted? But what's the percentage of convictions for charges based on all the other crimes? Put them all together. DUIs, put them on domestic violences, drug crimes, pick them. What's the breakdown there? Obviously, it's biased and partisan, and the courts are rubber stamping it. They love it, right? They go to cocktail parties, and we saw Judge Barrel was up there with Lisa Monaco doing whatever they were doing up there. Anyways, they say that the courts can just fix this. Well, that logic is circular, saying under the separation of powers, Article 3 courts cannot sit in judgment of the president's official acts, and the government cannot cure the unconstitutionality of that by invoking the aspect that is the most offensive of the separation of powers. That's the point, is you don't get to do that. And so Jack Smith, we can just solve that by just putting the courts in charge. Hello? That's the whole problem, is you're trying to subordinate the president's official acts under some other entity, which violates the whole concept of separation of powers. So they say the government emphasizes the public interest in the federal criminal prosecutions. We have, people who are saying, we need a speedy outcome on this because justice delayed is justice denied. And that this needs to get done now. And of course, we know that, the urgency here and really the framing of that is often for the defense, right? When you think about throwing somebody in custody for 5 years without prosecuting them, their justice is being delayed. That's on behalf of, generally the defendant. And the right to a speedy trial is often exercised on behalf of the defendant. We don't want the court to delay. But my point is, they're absolutely accelerating Trump's prosecution. They want to get him done in like 9 months with 14 million pages of discovery. And they say it's because of the people. Like, we need an outcome on this. Well, for the election, right? That's the point. So, but again, the government overlooks the great deterrence and the disruption to the president's functions from the threat of these prosecutions. And if you are now alleging that the president can be prosecuted for his official acts, it outweighs the government's interests here. The government says that criminal immunity would contradict the rule of law and that the president would be above the law, which is a dumb phrase because the president is. That's why they can pardon people. They say, no, I don't like that law. No, thanks. Not so. But in this case, the Supreme Court explained that immunity does not entail that the official is above the law, whereas here, absolute immunity is essential for the conduct of the public business. The Constitution mandates immunity here, which is the most fundamental law. Now, the government is also citing some other things, and they say that criminal immunity is sobering, and it would expose the nation to dangerous risks. They say, no, sorry, Jack. On the contrary, allowing a single prosecutor like you, who's illegally appointed, to sit in judgment over a president's official acts, that poses dangerous risks. The U.S. Senate, not the Special Counsel, has the constitutional authority and the political accountability and the institutional competence to determine whether the public interest justifies prosecuting a president for official acts. Not Jack Smith. He's not elected for anything, not appointed either or confirmed by the Senate at all. He's not acting on behalf of the people. He's acting on behalf of Joe Biden. So stop with the urgency for the public's interest. The Congress is structurally designed to consider and reflect the interest of the nation. That's the public interest. If there was enough constituency out there barking at the senators, convict Trump, they would have done it. That would have been the interest of the nation. But guess what? They didn't. There wasn't enough of that. Half the country, or maybe not half the country, but a good portion of it, said that there's not enough there. And so there was not enough, the 2/3 requirement, to actually convict him in the Senate. And so they failed. That is representation, all right? Not Jack Smith, who gets appointed by Merrick Garland. Now, as for the government's parade of hypotheticals that we read through and laughed at yesterday and at the prior in Jack Smith's reply, that Trump is going to execute Congress, like literally, that's his argument. The memo explains that concerns are addressed by the accountability of impeachment and removal. If they've engaged in serious criminal misconduct, easy. The Senate just convicts them. A president suspected of the most serious criminal, or like Nixon, I'm out of here, might well face impeachment and removal before his term expired, permitting criminal prosecution at that point. Impeachment first, removal second. Now, the government's concern that the practical obstacles to impeachment, like it might take some time, Congress takes a long time. It might prevent the prosecution of a president in some marginal cases. It misapprehends the doctrine of separation of powers. These are called structural checks. That's why we have a trial before we lock someone up, because you don't just go fast because you're very angry at Donald Trump. Against the government, it creates similar risks of under-enforcement, but they ensure that we do not lose liberty, okay? The safeguards, the checks and balances requiring an impeachment and a conviction before some demented prosecutor who doesn't represent anybody decides they're going to try to deviate the entire course of the election. No thanks. We want it to slow down. We want those safeguards. Now here they say, also constitutional text supports the presidential immunity. The government is arguing through Jack Smith. They say, the Constitution doesn't expressly provide for executive immunity. But the Supreme Court recognized there is absolute immunity and qualified immunity for other executive branch officials, neither of which are in the Constitution. So that's interesting. If the Constitution doesn't expressly provide for it, so what? The Supreme Court found it elsewhere. And there's a bunch of stuff that's not in the Constitution that they found in there. A lot of it, unfortunately, they found it, like Commerce Clause powers and so on. Now, some other rights are good. We have some right to privacy things that are in there too. Now, anyways, the text of the Constitution does explicitly acknowledge the president's criminal immunity. It does explicitly talk about it. Read the impeachment judgment clause, Jack. Next, in other words, that's the process for breaching the immunity. The president is immune unless this happens. Now, next, Jack Smith notes that impeachment applies only to high crimes and misdemeanors. Okay, but high crimes and misdemeanors encompasses official acts of the president that the Senate deems sufficiently serious to warrant removal. Things that are of a nature which may be peculiar with propriety be denominated political. Okay, so this is a quote from Federalist 68. They say, thus, in the Constitutional Convention, they thought the Senate, okay, was the most fit depository of this trust. The Senate does the trial, not the Supreme Court. They rejected the Supreme Court as the appropriate venue for the trial. Now, the government is saying Alexander Hamilton made some quotes that don't serve Trump's argument, but they say, no, Hamilton was well aware that the president could also leave office upon the expiration of his term. He made this point multiple times. Right. So this is another argument. They say Jack Smith says, well, the president, he could commit a bunch of crimes and then leave office and they couldn't impeach him because he's not in office anymore and blah, blah, blah. They say the president of the United States would be liable to be impeached, tried, convicted. If he is convicted of treason, bribery, or other high crimes and misdemeanors, He's removed from office and would afterwards, after that, even after he's removed from office, right, then he's liable to prosecution. Now, they say Hamilton knew that the president could leave office upon expiration of the term. Hamilton made the point multiple times in the preceding sentences, but he did not say that the president would be subject to prosecution for official acts after completing his term. The government also cites that, and the government cites this one. But that is for subordinate officers below the president. Now, below the president is below the president. Now, they're also citing some other things from some other sources, and they're also relying on the pardon of President Nixon. They say, you know, the president, right, this is their argument, that presidents can be prosecuted because Nixon bailed. Nixon said, I'm about to be indicted or something, right? We don't know what he was going to do. But they say, okay, so he knew that he was going to be criminally charged. President Ford was pardoning him, and so that shows that the president can be prosecuted. And here, Jack Smith says, well, see, that's evidence that Trump can be prosecuted, even though Nixon was not prosecuted because he was pardoned, theoretically. Maybe he was not going to be prosecuted anyways, who knows? But of course, we said, okay, that was private conduct. It's outside of the official duties. So that doesn't apply, Jack. In any event, like the founders, President Ford emphasized the divisive nature of the prosecution of a former president. It's kind of an ugly thing. Shouldn't do it. And we're just going to put it to bed. Okay, so any other hacks out there back in the 1970s, 80s, 70s said that if you want to prosecute him, you can't. Sorry, we're not going to go down this ridiculous road. He said that the criminal prosecution of the president would prolong the bad dreams that continue to reopen a chapter. And so he made the same judgment the founders made before this country got infested with liberal psychopaths. Says the criminal prosecution of a former president should not and could not fairly proceed in Article 3 courts. It's not set up for that. Now, analogous immunity doctrines also support this. The government says that legislative immunity is limited to legislative acts. But this parallels the scope of immunity claimed by Trump, all right? His claims of criminal immunity are for presidential acts. The government says that presidential immunity came back from successive British kings. And they say, well, this point also supports Trump. In our structure, official immunity reinforces the separation of powers. We separate them so one agency can't subordinate another agency. And then the people are really the ultimate check for those political questions. But preventing this, they say separation of powers shields the president, no less than the members of Congress, from scrutiny and hostility for official acts. Now, the government cites a bunch of cases that we'll fast forward through. And here they get to this point. They say, look, this indictment violates presidential immunity. Jack Smith, he says that immunity might depend on the function that the president is performing. But we already rejected that in Fitzgerald. It would be difficult to determine the presidential function, and then you have some judge who's now determining whether that's legitimate or not. Now, the government says that immunity turns on the manner or the purpose of the president. And they say Trump wanted to rig the election or steal power, blah, blah, blah. They say no. Many cases hold that the purpose and manner is irrelevant to immunity. And third, and they give a bunch of cases: Spalding, Barr, Georgier, Biddle, Pearson versus Ray, Fitzgerald, and others. And third, the prosecution suggests that under a case-by-case basis, but they say anyways, finally, the government suggests immunity would be overbroad, but the same logic applies here. Now, all of the acts from Trump, they all fall within the outer perimeter. Anything the government says is unconvincing here. They say that Trump made public statements that were supposedly knowingly false. And they say that's ridiculous, knowingly false. The government's empty assertion, that's utterly false. Punks! You think it's knowingly false? Well, you're utterly false. Illegal Jack. They say President Trump was carrying out his duties as the chief executive to investigate the overwhelming reports of widespread fraud, but nevertheless, absolute immunity would apply even if the statements were allegedly false, which were not the case. The government argues also that this is part of private actors. They say no, there's overwhelming involvement of official staff, and private actors only played a minor role. And so the impeachment clause also prohibits a new set of charges because we've got double jeopardy that attaches, saying the government's minimal historical evidence contrasts with our extensive evidence. We have more sources than you. They ignore much of what we've given you. What the government does is misapprehend Hamilton's statements. They say in his description of impeachment, Hamilton thrice indicated that prosecution follows Senate conviction. So per Hamilton, an acquittal means prosecution cannot proceed. So their double jeopardy analysis is also terrible. They say President Trump did not assume that the impeachment penalties and process are criminal in nature. We didn't assume that. We showed it. Impeachment was adapted from the English, which was criminal, included removal and disqualification. And so we suggest that removal and disqualification are criminal prosecutions. In fact, Blackstone thought so too. So did Hamilton. And so as we were going to say, they were going to, well, it's not double jeopardy because the first impeachment and trial was not really like a criminal proceeding. It's not like really bad. It's like kind of like a parking ticket. And so you can only have jeopardy when there's like a real thing that attaches. Or you were placed in jeopardy. Like you could have gone to prison on this thing, man. You got acquitted though. And say Trump would be impeached and removed from office, right? Never to run again. I think that's pretty serious business. And then open to other criminal. So they say, well, it's not really a jeopardy. And they're saying, of course it is. We say the government says that it's not enough, but they say principles of double jeopardy apply to impeachment, even under the Fifth Amendment test. And so we're answering the government's analysis here. They say here, double jeopardy protections emanate from the impeachment clause. And while double jeopardy principles are relevant, the key is what will effectuate the constitutional purpose of the clause. And that requires dismissing the prosecution because the prosecution, it undermines the Senate's judgment. The Senate already decided this on behalf of the people, our representative body, and they acquitted him. Sorry, Jack. So they say, therefore, Judge Chutkan's terrible order should be reversed. Love the filing from John Sauer on behalf of Donald Trump and other attorneys attached there, submitted into the D.C. Circuit Court of Appeals. And so this is the final word. We're going to now be back on January 9th. So make sure you're subscribed wherever you're watching this because there will be oral arguments on this. The D.C. Circuit Court of Appeals will make a decision, and then very likely they're going to affirm portions of Judge Chutkan's decision. And I would imagine the prosecution is going to continue forward. Now we'll see what their ruling says and where Trump's team takes it from there. But let's get some reaction to this. Of course, the Biden White House, the people who are responsible for getting Jack Smith appointed in the first place because Joe Biden was unhappy that Merrick Garland was dragging his feet and stopping Trump using the legitimate institutions of our power. And so they're now out hitting the same standard talking points. This is a Biden spokesperson. His name is Quentin Fulk. And he says that Republicans, like Trumpers, are literally, look at this, an existential threat to democracy. Joe Biden's going around on his insurrection anniversary tour, and he's going to be hitting this point that Trump tried to steal the country over and over again.
Why Valley Forge for Saturday? Are you expecting a cold winter?
No, we're expecting a very good winter come next November. But look, we chose Valley Forge. George Washington, as you just said, unionized colonies there and brought them all together. And then he became president and set the precedent for, a peaceful transition of power, something that Donald Trump and Republicans refused to do just as late as yesterday. We believe that they pose an existential threat to democracy. And over the last 4 years, that threat to democracy has only grown.
Why Valley Forge
so what are
for
you going to
Saturday?
do? if somebody is an existential threat to democracy. I mean, like, you can't let that person win, right? Like, you have to prosecute them, you have to imprison them, you have to censor everybody who is supporting them. Like, it's a new attack on the country, right? And we said this years ago, that Donald Trump is going to insurrect the country again, is going to be the new talking point. And that is a national security concern. Like, as this escalates, it's a threat to democracy, right? That used to mean something like significantly, like, wow, man, the terrorists are going to come and attack American democracy. Like, we're all going to die. I know they still think that way. Many of us have waken up feeling duped by that whole thing. But this is the new thing, right? We're under attack. We're under attack. We're under attack. It's nothing but fear to motivate their base. They had the COVID, fear nonsense. They got climate change nonsense. They got abortion. They're stealing away your everything. And now it's insurrection season yet again. And it's going to be the whole thing in 2024. Now, I've got concerns about this because there are consequences to this, right? These people hold power. These are not just empty words from Karine. Like the FBI, the CIA, these are the people who might say, yeah, we have to stop this from happening to save American democracy. And this is the Biden White House out there with these ridiculous talking points. Now, here's a question. What happens if the Supreme Court does nothing about this? What happens if SCOTUS takes a look at what the Court of Appeals has done in the DC Circuit and says, yeah, that's pretty good enough for us. The case goes back down. We go back onto trial, and we may actually get a conviction. Maybe Judge Chutkan holds the March trial date. We don't even know. We'll see what happens. But this, of course, is Andrew Weissmann. He's a contributor over at MSNBC. He has a full podcast called Prosecuting Donald Trump. And we're going to listen to a small segment of it here. He's on with Mary McCord, and they're talking about this Jack Smith case. What's going to happen, guys?
And what Jack Smith had sought was to leapfrog the D.C. Circuit and go straight to the Supreme Court. The Supreme Court said no to that, at least for now. Doesn't mean they'll never take it up, but they said, we're denying that. I think in some ways that's because the D.C. Circuit moved so fast to schedule the briefing and argument that the Supreme Court probably thought, let's see what they could do. They might be able to avoid ever taking this if they end up just basically agreeing with what the D.C. Circuit did.
I just want to make sure everyone understands what Mary's saying is it is possible that the D.C. Circuit will issue its decision. I think by all accounts, it will hear this a week from today. It could rule very, very quickly. It is possible that the Supreme Court will take it. I think you and I both think it's probably likely they'll take it. But I think people should remember the Supreme Court could just say, you know what, we're going to leave it as is.
And what Jack Smith...
I don't think they're going to do that. I think that they're going to take it because this is a major issue. But they could. And, we're trying to speculate what could get this case back on track, right? Something like that could happen, maybe it does happen, or I don't know, we'll see. So that's what they're talking about over on his podcast. Now, here's Christina Bobb, one of Trump's attorneys, also articulating her perspective on this, saying that the immunity provisions absolutely protect Trump from this criminal prosecution. Here's Miss Bobb.
Sure. For the presidential immunity, I think that they should rule in favor of Donald Trump. Presidential immunity has been in play for the vast majority of our history. It's well established if the acts alleged in this indictment are in the furtherance of his office, in accordance with his political office, he's immune from prosecution. Clearly, as the president of the United States, he believes that there was fraud in the election, and he had a constitutional obligation to try to secure the election and figure out what was going on. So this is a very clear case. He should be covered by presidential immunity. I don't see them ruling differently, but we'll see how that all plays out. And then as far as the ballot selection goes, the case up from Colorado, I think that will be decisively in favor of keeping Trump on the ballot.
I think she's right about both those. And it's going to be very curious if the Supreme Court comes out and says, no, the president doesn't have any immunity for official acts. Because where are they going to draw the line? Like, is it only going to be official acts that are involved in insurrecting America? Like, what kind of rule are they going to craft? What is the limiting principle for the left on this? So there is no immunity for the president. So that means that we can prosecute Joe Biden. We can prosecute Obama for executing 2 American citizens without any due process of law. Is that fair game? Can we go after George Bush for lying us into 20 years of war? Is that fair game for all the presidents? I was like, okay, if we're going to go down this route, we're going to go down this route. And of course, the Supreme Court, I think, is going to have a lot more sense than these political partisan hacks. So we're going to be here continuing to cover this, my friends. Don't forget to check out watcherlodge.com to go check out our fitness challenge so that you can stay fit and fortified. We are still signing up. We've got until February 5th to get your 31 days in. We're on day 3 right now, and we're posting our fitness updates here. So come in, drop your fitness success in the comments at watcherlodge.com, and we'll see you over there. And of course, we'll be back here as well to dig into what's happening in the immunity case. We'll be back here for oral arguments as well on the 9th, and so we hope to see you. Thank you for subscribing wherever you're watching it. We'll look forward to seeing you on the next one. All right. And now, let's turn our attention over to former Attorney General Ed Meese. And Vientikis is in the house. Thank you, V. Very nice to see you in the house. We got that chat pinned up. Ooh, we got another 43-page filing today to overturn the Colorado Supreme Court. Man, there are so many filings. It's going to be a great year. We're going to have so much to get through. All right. Now, this is a fun one. And we've already seen some of this, but this is a fresh one. This one's out of the oven. Former Attorney General Ed Meese, who used to be the Attorney General for Ronald Reagan, submitted an amicus brief here in the D.C. Circuit Court of Appeals. This is the Trump immunity case. And Ed Meese has already submitted one of these before at the Supreme Court, which we read through here. Supreme Court, however, rejected Jack Smith's attempt to leapfrog the Court of Appeals. And so the Attorney General's brief was not considered, or at least ruled upon, as far as we know, by the Supreme Court. And so now that Jack Smith, in his race to convict Donald Trump, now that he has to actually go to the Court of Appeals, and we're scheduled for oral arguments at the Court of Appeals on January 9th, I hope you join us, we're going to be seeing the arguments may include this filing, which is from Attorney General Meese. And the substance of this argument is Jack Smith is illegitimate. He was not properly appointed by the president. He's not part of the Department of Justice as a U.S. attorney who's been appointed and confirmed by the Senate. And so what they're doing by having the Special Counsel's office prosecute Trump is entirely illegitimate and unconstitutional. And what's curious about this argument is that, as we can see here, the Court of Appeals has responded and says everybody who shows up on the 9th, you better be ready to talk about this stuff. You see, it's a very simple order that the court brought out on their own, sua sponte. They submitted this January 2nd, Happy New Year, saying, hey, when you guys show up on January 9th, it is ordered on the court's own motion that the counsel, you guys, be prepared to address any inquiries by the court regarding discrete issues raised in the briefs filed by the amici curiae, okay, friends of the court, signed on here by the clerk of the court, and this is before the 3 judges. So it's the 3 judges that were picked at the D.C. Circuit. It's not going to be the full panel, and of course, we'll see if Trump wants to get the full panel after the ruling comes down. But this is here interesting because what amicus brief are they talking about? Is this Edwin Meese's that say that Jack Smith is illegitimate? Are we going to get a ruling on that from the District of Columbia Court of Appeals? We don't know. But there are also other people filing amicus briefs, and I think others are including Judge Luttig. You remember him, who talks very slow, makes you want to jump out the window. But he submitted a brief, and what's curious about this, as we read through this, we're going to see that Jack Smith is illegally appointed, right? The special counsel statutes that they use to concoct this office are illegitimate. What's funny is Liz Cheney is saying Donald Trump's going to appoint people who are illegitimately appointed to do his bidding, literally as it is happening right now before all of us. And so let's take a look at the filing. Former Attorney General Ed Meese submits another amicus brief to the D.C. Court of Appeals on appeal from Judge Chutkan's courtroom. It's a 44-pager. We'll hit the highlights with oral arguments set for the 9th. We know that they may be asking questions about this, which is going to be great. So here's the brief. We got the law professors. Shout out to Stephen G. Calabresi, amazing dude, and Gary S. Lawson, absolute awesome bro as well. Shout out to Edwin Meese, who's all submitting this here. So they write, briefly, this is why we're submitting this. Here's our disclosure. We're not writing this on behalf of anybody else. And here, we'll fast forward through the table of contents and the authorities and get to the goods. Now, first, before we get there, are these a bunch of partisan hacks? These are law professors and former attorney generals. He says, given the interest in the rule of law, and remember, no one's above the law, not even Jack Smith. The legal issue this brief addresses is very important to us. The Honorable Edwin Meese was the 75th Attorney General after having served as the counselor to President Reagan. He's now a distinguished fellow at the Heritage Foundation. And during his tenure, the department defended proper limits on federal power. And professors Calabresi and Lawson, they're scholars of the original public meaning of the Constitution. Members of this court, you guys, Court of Appeals, you've cited them. That's how smart they are. And they're back here in front of you. You cited them in 2018, Pillard. You cited them also, Rogers, back in 2007. So these aren't just any old people. And so we, the amici, the friends of the court, we urge this court to vacate Judge Chutkan's judgment and order a dismissal of Donald Trump's prosecution for failure of prosecutorial authority. Woo! Man, we love that. Hey, Jack, you don't even have any authority. Everything goes away. Thanks, you're done. Go home. Now, here's the summary of their argument. Dear Court of Appeals, former Attorney General says, along with two brilliant legal scholars, law professors, Jack Smith does not have the authority to conduct this prosecution. Now, those actions can be taken only by persons properly appointed as federal officers to properly created federal offices. Neither Smith nor the position of special counsel under which he purportedly acts meets those criteria. And that is a serious problem for the American rule of law. Whatever one may think of Donald Trump or the conduct at issue here, this is important. Now, the illegality addressed in this brief started in November 18th, 2022, when Garland exceeded his statutory and constitutional authority and purported to appoint Smith to serve as the special counsel. Now, Smith, according to his document, this was the filing, right? This whole section here. He says, Smith was appointed to do the following: to conduct the ongoing investigation whether any person like Donald Trump interfered with blah, blah, blah. Now, Attorney General Garland cited in that order his authority under these U.S. codes, 509, 510, 515, 533. But none of those statutes nor any other statutory or constitutional provisions even remotely authorized the appointment of Jack Smith. They appointed a private citizen to receive extraordinary criminal law enforcement under the title of special counsel. Now, first, they say the appointments clause. So every time you say, why is Jack Smith illegitimate? Appointments clause. It says that all federal offices that are not otherwise provided for in the Constitution must be established by law. We know that there is no statute, there is no law that establishes the office of the special counsel. Now, the provisions that the DOJ perverted and concocted over the past half century, they do not authorize the creation or the appointment of the special counsel at the level of U.S. attorneys. There is no authority for this. And U.S. versus Nixon does not hold to the contrary, because that question was never raised in that case. That case was about the president and the DOJ, not between the president and any specific actor purportedly appointed by the DOJ. It was about the institution, not Jack Smith. And second, even if one overlooks the absence of any statutory authority for this position, there is no statute that specifically authorizes an attorney general, like Merrick, rather than the president, like Biden, with the advice and the consent of the Senate, to appoint a special counsel. So in other words, the appointment of Jack Smith needed to come from Biden. not from Merrick Garland. Under the Appointments Clause, inferior officers can be appointed by department heads only if Congress so directs by statute. See the Constitution. And so directs specifically enough to overcome a clear statement in presumption in favor of presidential appointment and senatorial confirmation. So there is no statute that exists for the special counsel. So in other words, Merrick Garland can appoint people to different offices, but Congress has to establish those. And third, special counsel, if he is a valid officer, he is a superior officer or a principal rather than an inferior officer. If he is even a valid officer, and thus he cannot be appointed by any means other than by the president. President has to appoint, Senate has to confirm, because Jack Smith is a principal. He's a superior officer based on his duties. Now, this is true as a matter of original meaning. It's true even as a matter of case law. None of these cases can plausibly be read to say that any person who is in any fashion subordinate to another executive official other than the president is an inferior officer, right? Jack Smith is on his own. Such a reading of those decisions leads to ludicrous results that there is only one non-inferior officer in every executive department. But they say, to be sure, there are times when the appointment of a special counsel is appropriate. Oh, okay. Is that true? Let's see. He says, and there are statutes, and the Constitution provides both ample means for those appointments by allowing the use of existing U.S. attorneys. You got to be an existing attorney. Any number of U.S. attorneys have performed with distinction as this special counsel. For example, we've done this before. Patrick Fitzgerald, back in December 2003, he was the U.S. attorney for the Northern District of Illinois, appointed by the president, confirmed by the Senate. He was lawfully appointed by then acting attorney general to investigate Valerie Plame, the Dick Cheney leak, which arose within the jurisdiction of D.C. Mr. Fitzgerald, who was a Senate-confirmed officer of the United States, prosecuted and secured the conviction of Dick Cheney's chief of staff, Scooter Libby, in the U.S. District Court of Columbia. Other examples, we had Rod Rosenstein, special counsel, John Huber, special counsel. They were all Senate-confirmed U.S. attorneys. Weird. John Durham was another one. Now, all of these investigations and prosecutions were of high-level wrongdoing. They were all lawful. So why didn't they just pull someone from the DOJ? Why'd they have to go get Jack Smith from the criminal court? Oh, interesting. So what federal statutes and constitutions do not allow, however, is for the Attorney General to appoint a private citizen like Jack, who has never been confirmed by the Senate, as a substitute U.S. attorney and then just give him a new name tag. You're the special counsel, Jack. This is what happened on November 18th. That appointment was unlawful, as are all the legal actions that have flowed from it. Everything from day one. Unlawful, including Smith's current prosecution of Donald Trump. Man, that's some good stuff. Now, they say no statute authorizes Jack Smith's position. They say in our constitutional system, Congress alone has the authority to create federal offices that are not established by the Constitution. It's written in there, or Congress can create it. The executive branch, which is the DOJ, they don't just get to say, we're going to create a new office. That's a little too much power for them. And the Attorney General cannot ex nihilo fashion offices as he sees fit. Nor has Congress given the Attorney General the power to appoint a special counsel of this nature. And so thus, without legally holding any office, Jack Smith cannot wield the authority of the United States. He has none, including this prosecution. Now, the Constitution says that only Congress can create a federal office. It creates, the Constitution itself, it creates no executive positions other than the presidency and the vice presidency, if you consider it that. But instead, the Constitution commits the power to create federal offices to Congress. They say Congress shall have the power to do whatever is necessary and proper. It says all laws which shall be necessary and proper for carrying into the execution the foregoing powers as a check on the executive, Congress says, okay, we think you do need this. People think you need this. We think you need it. So we're going to give this over to you, and then you can run with it. All other powers, they say, and all other powers vested by the Constitution. Okay, so Congress has the power. Now, a law creating offices to carry out executive functions is the quintessential law necessary and proper for carrying into execution federal powers. English monarchs could do things. Founders thought that when English monarchs created offices, right, if the executive can create their own offices, it's like they're just going to create a gazillion offices, obviously. We need that. We need that. We need that. But the founders considered this power abusive, and they said, no, we're not going to give you that power. Congress gets to tell you what you need. And so accordingly, the Constitution does not give the president or the DOJ, like Merrick Garland, the power to just create offices out of thin air. Instead, it requires that Congress first create all the offices, and then once Congress creates them, the executive appoints the people to them, and the Senate confirms them. That's the Appointments Clause. And they continue, lot of summation there. They say the DOJ's current structure that is provided by the law, what we have now, here's what it defines. Let's see if special counsel's on this list. Attorney General, Deputy Attorney General, Associate Attorney General, there's like way too many. Solicitor General, 11 Assistant Attorney Generals, 1 U.S. Attorney, okay, for each district, currently got 94 of those. The Director of the FBI, Director of U.S. Marshals, 1 U.S. Marshal for each district, a Director of ATF, Director of Bureau of Prisons, 21 U.S. Trustees, and as many U.S. Assistant U.S. Attorneys, and you see this one, Special Attorneys, as the Attorney General deems necessary. But this list does not include more than the 100,000 people who work at the DOJ. They are there. They are working there. They are not officers of the United States. They're employees. They don't need to be appointed by the Appointments Clause. Ethics in Government has also considered this, but Janet Reno, and we know some of the history here from the first filing, but Janet Reno, she said, you know, she wrote this opinion. She said, sometimes we can appoint outside special counsel. So we don't need like special counsel. We need outside special counsel. And that means someone from outside the United States government. And the Reno regulations, when she created this, she cited these laws. And in his order, Attorney General Garland cited the same thing. But unfortunately for Garland, these statutes, whether you look at them one by one or together, they provide no authority for this. And we've gone through this, right? And this analysis is they say, okay, Merrick Garland said Jack Smith is appointed under U.S. Code 301, 5 U.S. Code 301. You read it, it doesn't say anything about special counsel for Jack Smith. It's a housekeeping provision. It doesn't create any offices or the abolition of any offices. Nothing in there. Next, they turn to Section 509. That one also doesn't provide for this. This provision doesn't create any office as well. It says it just means that Merrick Garland can control his subordinates. Attorney General may also make provisions for the performance of his employees, but it says nothing about who those persons are or how they got there, right? Nothing in that law, 510, gives them permission as well. So then they turn over here to 515 to 519. But again, alone, none of these provisions comes close to even authorizing the creation of a special counsel or the appointment by the Attorney General of a private citizen. Like there's no law for that. Section 515 doesn't include it either. It's a geographical and jurisdictional provision, not a grant of power. For example, as we saw, Patrick Fitzgerald was Senate confirmed. He was pulled out of Illinois to work on the Valerie Plame affair. Similarly, okay, this doesn't give power, this doesn't give power, and this doesn't give power. Now, Section 519, however, does point to the correct answer regarding the authority to appoint a special counsel. But that notes that special attorneys are appointed under Section 543. And that is explicit authority to appoint special counsels. But why didn't they reference Section 543? Well, because it doesn't authorize the kind of special counsels that they want. It's narrowly cabined. 543 says that they may appoint attorneys like tribal prosecutors and other qualified attorneys to assist in prosecutions in Indian country. Okay, so it's not applicable to them. It's just special who merely assist the attorneys, not go and do their own investigations as fake independent prosecutors. Now, they say that there might, and we know that there might be many instances when they want to bring someone in. For example, private lawyers have a lot of expertise in banking, antitrust, tribal law, and so on. But that's not what this is. Jack Smith is not a special counsel. He is not assisting a U.S. attorney. Jack Smith was not appointed to assist anyone. He was hired as a powerful standalone officer who replaces the actual U.S. attorneys, and this is precisely the role that was used for independent counsels, which is no longer in law. But that statute no longer exists anymore. And so we know that this is, okay, everything that they're relying on doesn't give them authority to have Jack Smith here. Officer is a constitutional term of art. Congress can try to impeach the deputy AG or the FBI, but no one thinks Congress can impeach the DOJ trial attorneys. No one thinks investigative officials who are bureaucrats and employees can be put in line of succession to the presidency. And so they're reading this very cavalierly, but they say at a more granular level, the effect of a loose reading of these statutes is even more bizarre. Congress has provided for the appointment, all with presidential nominations of all of these people. And a reading to do really what they're asking, which is to create unlimited inferior officer appointment. It wreaks havoc on this entire structure of what their Constitution says. It would allow the Attorney General to appoint an entire shadow DOJ to replace the functions of every statutorily specified officer. No wonder the Reno regulations did not invoke that authority. And so for these reasons, they say the position held by Smith was not established by law. The authority exercised by him as a so-called fake special counsel, it far exceeds any power exercisable by a mere employee. He's acting as an officer. But aside from the specific offices listed in the statutes, there is no office for Jack to hold. Womp, womp, womp. That alone robs him of authority to represent the United States in any capacity. Now, even if one somehow thinks that he is authorized and there is an actual office, Smith was not properly appointed even to that office. No statute clearly authorized his appointment. Any such statute is governed by Article 2. It says the president shall appoint the people to those offices, and the president alone. The default mode of appointment is presidential nomination. Senate confirmation happens next. Nomination, confirmation, appointment. That's the process. It can only be overridden in Congress for inferior officers. And so what they've done here is outside of that structure. They tell us it's unclear why Congress chose to give general inferior officer appointment to the aforementioned secretaries, but not to the Attorney General. It may be because of the unique threat that an unprincipled Attorney General could pose to civil liberties, like what's happening now. The separation of powers and federalism, But this court need not divine Congress's reasoning for making these things. The statutes are unambiguous. If Smith actually had the power to convene grand juries and issue subpoenas, he would be an officer of the United States if he could do that. More than that, he would be a superior officer. And if he is a superior officer, that means the appointment clause applies and he must be appointed by the president. That is not how Smith was appointed. He could not serve as special counsel even if the office existed. Saying that under Reno, the idea of special counsels are even more powerful than U.S. attorneys. It's obvious that U.S. attorneys are superior offices, and the same is true of special counsels. The only plausible argument to the contrary is an overreading of those decisions from the Supreme Court. But if those were true, the whole system would be upended. Could Congress therefore let the Attorney General appoint Court of Appeals judges or the Solicitor General or the FBI? No, of course not. They say one can be a superior officer in a couple of ways, and Justice Souter has made similar points. But either way, if he is an officer, Smith is a superior officer. He has no superior supervising him, and a Garland does not supervise or direct him. As Garland has said, no, I have no idea what he's doing. As he said he would not when Smith was appointed. Now we know that he's here for a reason. And Smith is appearing in this court, at the Court of Appeals, on behalf of the United States. He is prosecuting a former president, the first time this has happened in our nation's history. Smith is purporting to exercise at least as much power as a U.S. attorney and arguably much more. That is the hallmark of a superior officer who must actually be appointed. Now, the absence of that appointment means that Smith lacks the authority to prosecute Trump on behalf of the United States. And that is a powerful and a sufficient reason to vacate the decision below in order that Jack Smith's case be dismissed. Saying Jack Smith is making arguments that the panel, he's saying that now judicial economy points to addressing this now. If the case is remanded, the panel is accordingly free to invalidate Smith's appointment, and you should do so. So in conclusion, they write, not properly clothed in the authority of the federal government, Smith is a modern example of a naked emperor who has no clothes, like Judge Engoron. Illegally appointed, he has no more authority to represent the United States in this court or in the underlying prosecution than Tom Brady, Warren Buffett, or Beyonce, all of whom would do better jobs. Now, that fact is sufficient to sink Smith's prosecution of Trump, and the court should vacate the decision below in order that the prosecution be dismissed. We express no views on the substantive issues addressed in the parties' briefs. Not even asking. Immunity, don't care. Double jeopardy, don't care. Insurrection of America, don't care. Jack Smith is not a legally appointed person. He's a private citizen, not a U.S. attorney. And the statutes don't provide for his office. Case is garbage and should be thrown away immediately, and all charges dismissed. And an apology letter written from the DOJ, and Trump should file a lawsuit for damages. Now, this is Liz Cheney. Now, we just got done listening to the read of the brief from Ed Meese, where we know that Jack Smith is not lawfully appointed. Illegitimate, the entire thing. Listen to Liz Cheney lecture us about how Trump is going to do that. Trump is going to turn around and appoint illegitimate people. It's unbelievable, the projection.
Well, I think that he's told us what he would do, and his actions have been very clear. First of all, he will ignore the rulings of the courts. And when you think of the danger that presents to have a president in office who's unwilling to enforce the rulings of the courts, who has, frankly, gone to war with the rule of law, there's nothing that will stop them. No guardrails will prevent that. He will obviously put in place people who will do his bidding, whether or not they can get Senate confirmation, for example. He won't be stopped by failure of the Senate to confirm key leaders. And he's
like
told
Jack.
us the kinds of people he will put in place. People like Mike Flynn, who suggested that he should deploy the military to quote, rerun the election in key swing states. People like Jeff Clark, who clearly demonstrated his willingness to put the entire power and weight of the Department of Justice behind Donald Trump's lie, attempt to overturn the results of the election. And so you'll be in a situation where none of the people who stopped him in 2020 would be willing to serve, nor would he accuse those people.
Mm-hmm.
And of course, he is unlikely to leave office. You know, he made very clear he attempted to seize power once before.
Oh, gosh.
I think there's no question he would do it again. So I think the threat is very real. We have to take literally and seriously what he says.
Yeah.
What he claims, what he would do.
Literally, that's exactly what they're doing, okay? They have an unappointed private citizen called Jack Smith, who they just poked over from the International Criminal Court, brought him in here, said, you hate Trump. Why don't you just go hog wild against him? Shatter 234 years of precedent. Trump left office. Hello, Liz. Already's done that once before. The question is, are they going to allow an election? Are they going to leave their office if the American people vote for Trump? Liz Cheney, using and regurgitating the old garbage talking points that she's getting, pretty practiced at. And we'll be continuing to cover this, my friend. So the Court of Appeals will be having oral arguments on this. They are now telling the parties, be prepared to argue these briefs. Trump's lawyers, be there. Jack Smith's lawyers, be there. Justify your existence before us. Hopefully we get questions like that. We'll be here to continue to cover it, my friends. Thank you for joining us as we do. Don't forget to subscribe wherever you're watching this. Thanks for checking out robertgovea.com for the newsletter. Head over to thewatcherlodge.com. That's where you can sign up for the fitness challenge and join the lodge. We've got a lot of other activities at watchingthewatchers.locals.com, where we do members only streams and Saturday shows. And so come check us out. Links are in the description below for all of those. We'll look forward to seeing you back here on the next one. All right. And now, my friends, we got one final segment on the day, and we're going over to Maine. Donald Trump sues Maine's Shenna Bellows for throwing him off the ballot there in Maine. And we're going to go through the lawsuit, which was submitted to the Maine Superior Court. Not too long, just kind of simple, actually, saying, hey, here's what the Secretary of State's authority is, and here's what she did. And this is why it's unconstitutional. Her name, of course, is Shenna Bellows. She gets asked about this from CNN. Is what you're doing here good? Is it going to survive? People are asking, is this going to fracture the country on the Mika Brzezinski show? So she's saying, is there any backlash, and should we care anyways since he's a dictator? Raskin says Trump must be disqualified. But over on CNN, they're kind of hinting at this, saying all this removal stuff is not going to be good for our side. And Comer's recognizing this is election interference. And so let's jump right in to the filing. Donald Trump versus Shenna Bellows filing a complaint against her for a review of her so-called opinion. Remember, she's not a lawyer or a judge or anything even close. It's in the state of Maine over to the Superior Court. Under an introduction, they tell us, all right, Superior Court of Maine, Donald Trump is here, and he's asking this court for a review of the final order issued by Shenna, calling it the ruling, the secretary's ruling, which I like. A copy is attached. We've already read through it, that she didn't write. Now, in response to a challenge, the Maine Secretary of State, Shenna, she removed Donald Trump from the Republican Party's primary ballot. She said that he is allegedly ineligible to be president under Section 3 of the 14th Amendment. And they say President Trump is not happy about this. They say he is aggrieved that the final order is out. Why? The secretary was a biased decision maker who should have recused herself. And we read through the recusal request from Trump's team before the ruling came out. She also otherwise failed to provide lawful due process because there was no real hearing that took place. And also, the secretary had no legal authority or any other Maine statute to consider the federal constitutional issues that were presented. And 3, she made multiple errors of law, go figure, no surprise there, acted in an arbitrary and capricious manner, and that President Trump will be illegally excluded from the ballot as a result of her actions. And so they continue. Trump states the following. Obviously, he is a petitioner, resident of the state of Florida, a candidate for president. And Shenna is a Secretary of State of Maine. Now, Trump's upset. Why? Presidential ballot access is governed by this Maine law. For a placement on the ballot, candidates must submit petitions containing a certain number of signatures. It's undisputed that President Trump had a bunch of signatures because he's very popular. Now, in addition, it also requires a candidate to file a consent form. And this is where Trump is going to say, here's what I filled out. Each candidate has to complete a consent form. It says they must contain a statement signed by the candidate. The Secretary of State shall create a form, a single filing sufficient, declare your residence, and as required on the consent form, this is what it looks like. Here's what Trump filled out. He says, okay, all right, somebody's filling out for him. All right, Donald Trump, Republican, loser party. Maybe they put MAGA party. I don't know what they put in there. Legal name, Trump. First name, Donald. Phonetic pronunciation, you know how to say it. Voting residence of the candidate. Okay, there that is. And hey, look at this. Here's the form. Qualifications for president. Donald Trump's saying, let me think. Am I a natural born citizen? Yeah. Have you been a resident of the United States for at least 14 years? Yeah, got that one. Are you 35 years of age? Yeah, got that one too. That's it. Those 3 qualifications. Boom. There you go. U.S. Constitution, Article 2, Section 1 is their authority for that. So the candidate says, I hereby declare my intent to be a candidate for the president. And I want my name to be placed on the primary ballot to be held on March 5th, 2024 in the state of Maine. I further declare my residence in my municipality is above, and I am enrolled in the party name above. I meet the qualifications to hold this office listed above, and that this declaration is true. Boom, that's it. So then Trump says, okay, Donald J. Trump, and he has that real kind of aggressive signature, which I dig, actually. It's great. Subscribed and sworn before me on this date, Notary Public. They sign it in there. And that's it. Got to get this all submitted by December 1st. That's it. It doesn't say anything in here about insurrection, right? No insurrection question. So there is no dispute that President Trump submitted his consent, his duly notarized form, all submitted. In fact, we've submitted it here if you want to look at it again. And by submitting this consent, Trump met all requirements set forth by the legislature. Okay, that's it. He was done. The form was completed. The law says it's the form. That's it. But nonetheless, the secretary denied Trump from going on the ballot because there was no notice about anything. So here's the grounds. They say, look, relief is sought upon the grounds that this was a process that was infected by bias and pervasive lack of due process, calling it arbitrary, capricious, characterized by Bellows's abuse of discretion, errors of law, ultra vires, things outside, unsupported by substantial evidence on the record as follows. 1, Secretary should have recused herself due to her bias. We documented her history. She was in that little, Spice Girls insurrection meeting where they were all having their, estrogen fest, whatever, talking about insurrection in their Secretary of State offices. Weird debacle there, but they did it. So we saw that. Okay, Trump was an insurrectionist before this even landed on her desk. Secretary denied President Trump due process by failing to give him adequate time and opportunity to present a defense. Secretary lacked the statutory authority to hear the challenges directed by Trump's supposed disqualification. Said here, the law provides us with mechanisms to challenge this. Section 336 specifically says declarations, statements in here. But no challenge was made to Trump's place of residency. No challenge was made to Trump's party. And so the secretary had no authority to consider any challenge to Trump's qualifications because those qualifications are not on the form, right? In other words, the declaration, somebody could have challenged his declaration elsewhere. Now, even if the secretary could consider challenges to the statement portion of the consent, any challenge is limited to the plain text of the form on this by the secretary. That's it. In other words, it's on the form. I filled out the form. That's the end of the discussion. The limited scope of the statement means that any claim about Section 3 of the 14th Amendment, it's not there. It has no bearing on anything on the consent form, much less the declaration. The secretary had no authority to consider the challenges raised under the 14th Amendment. If they want to change the form, they can, but they don't just get this, well, I got to consider anything else. So by exceeding the scope of what Maine legislature said, here, Trump's sworn statement was factually true. And so it was an error of law. It was an abuse of discretion for her to find it false. And now all of the evidence on which she relied was also irrelevant. None of these issues were before her. She abused her discretion by relying on untrustworthy evidence that came from the January 6th committee. Even if Maine authorized the secretary to consider challenges to Trump's candidacy, which it did not, the secretary could not have properly considered Section 3. Why? Disqualification of a president is a political question reserved for the Electoral College in Congress. And the 14th Amendment is not self-executing. That has not been established. Section 3 also, they say, bars persons otherwise subject to its disqualification from holding specified offices, not from running for them. By barring Trump, she violated that case. Another error. Section 3 also does not apply to the president because he never served as the officer of the United States. And it doesn't apply to him because that position is not an office, the presidency. Trump did not engage in an insurrection, and so this insane Maine secretary has said that as evidence of Trump's conduct, she relied entirely on his public speeches. Those speeches did not incite an insurrection, and they were protected by the First Amendment. And so now we demand that you vacate Superior Court Shenna Bellows' authority, her opinion, her ruling, and declare that she has no jurisdiction, no authority to maintain any of these proceedings under the 14th Amendment, and require her to immediately place Trump back on the ballot during the primaries and grant any other relief that we deem appropriate. Signed by Bruce Helpler. Shout out to Bruce from Portland, Scott Gessler, and Gary Lukowski. Bruce is signing on behalf of all of them, submitting this filing, this complaint against Shenna Bellows, the Maine secretary who removed Trump from the proceedings. Now, here is the question for her. They asked her, is this going to survive? Is this all just a big show? Or are you just trying to attack your political opponents? Here was the conversation with her on CNN.
Will survive this appeal by Trump and possibly survive the Supreme Court?
Thank you for having me. What I think is important to recognize is this is the process in Maine. Maine is unlike other states whereby anyone, a registered voter who challenges a candidate's qualifications must appeal to the Secretary of State. I did my job that I was required to do under Maine law and the Constitution in holding a hearing and issuing a decision. The next step under the law is this appeal to Maine Superior Court, and then the Maine Supreme Judicial Court, and then the U.S. Supreme Court. And I, on the last page of my decision, suspended the effect of my decision.
Why?
Pending the court process.
Why?
Because that is what's important, the rule of law and the Constitution.
Okay.
Do you think?
Well, they said that you don't have any authority to even consider this stuff, right? The Maine legislature told you what you could put on there. You put it on there, and now you just added another bullet point in there because you wanted to get rid of him.
It will survive the Supreme Court?
I'm not going to, I'm going to follow the will of the courts. I don't know what the courts will do. Whatever the courts will do, I'm going to follow the law and follow the court's direction. Certainly welcome the United States Supreme Court to weigh in.
If they disagree with you, what will that mean?
If they disagree with me, Trump will be on the ballot. And like I said, I stayed my decision pending the appeal because it's important that the process play out. That's what our laws require.
Tell us.
So doesn't actually say much, right? Always deferring back to the process. I'm just doing my job. I'm just doing my obligation. No, you weren't. You didn't have to go through that and conduct a hearing on it. You could say, hey, under the Maine legislature, it says, I consider these things. I don't have jurisdiction to consider your particular challenge. Take it up with someone else. But she wanted to remove Trump. We've seen her palling around with Jenna Griswold and all of the other secretaries of states at their little, entourage meeting. So she really doesn't care what it does to the country. She's just doing her job. She'll get her deal. She'll write a book about it. I'm under attack. You know how this goes. Raskin is saying that Trump is disqualified. He's been on this bench for a while. Trump's got to go. They've got no other responsive strategy to get rid of him. So this is the number 2 attack. He's also on CNN saying the law is very clear. You swore an oath to the Constitution, and you've got to uphold it. Here's Raskin.
Not just Republicans, though, coming out against this. We've heard Democrats and independents as well saying that they're not comfortable with this. Are you comfortable with one state official making a unilateral decision to take a presidential candidate off the ballot?
Well, the Constitution is the supreme law of the land, so we're all governed in our democracy under the rules of the Constitution.
Which is why Jack Smith has to go.
And it was actually two very conservative legal scholars who wrote the best, most authoritative law review article on the whole thing, saying that Donald Trump is clearly disqualified from being on the ballot because he...
A law review article. Okay, so couple people somewhere
participated in insurrection. So this becomes a test for the originalists and the textualists on the Supreme Court. And I think all of the justices from left to right call themselves textualists and originalists. The language of Section 3 of the 14th Amendment is very clear. It says, if you've sworn an oath to support the Constitution and violated the oath by engaging in insurrection or rebellion,
you think he should be off
you can
the
never
ballot?
hold
Yes
public
or no?
office again. And the original purposes of it are equally clear because actually when the language was first offered by the radical Republicans in Congress, it was very broad, and it said if you've participated in secession or insurrection, you can never vote again. And when it got over to the Senate, they said that's way too broad. Let's focus in on the worst offenders, people who'd actually sworn an oath to the Constitution and then breached the oath by trying to overthrow the government. And we'll make sure those people never serve in office again.
But
they
that
can
didn't
vote
happen.
again. Donald Trump can vote forever as long as he lives, but he has
Unless they convict him of a felony with their fake sham trial.
disqualified himself. And we have a number of disqualifications in the Constitution for serving as president. For example, age. I mean, you know, I've got a colleague who's a great young politician, Maxwell Frost. He's 26. He can't run for president.
Wow.
Now, would we say that that's undemocratic? Well, that's the rules of the Constitution. If you don't like the rules of the
That's his argument? You know, it's the age limit thing? Okay, so Raskin obviously does not want to answer that question, so he's just, babbling around about process. Well, no, constitutional rules and all this stuff. So Trump, he's saying that, yes, we got to throw Trump off the ballot, okay? We're petrified of the guy. He's going to beat us. He's going to expose our fake J6 committee. We're all going to be busted big time. And so they're just petrified. Now, here's another one. This one, the Mika and Joe Brzezinski show. She brought on this guy. He is also on MSNBC. Tom S. Elliott grabbed this one for us. Dave Arenberg over on MSNBC. He came on for some reason. He says the Constitution of ours has to mean something. Now, I think it's undemocratic to allow people to run for office who aren't qualified to do so. Right? They want him gone. And Mika doesn't really care about the ramifications of this because they hate Trump so much. They're demented. Listen.
You know, there could be a backlash, and that's something that might need to be considered, some might say.
Yeah, maybe.
Is a Supreme Court justice or a Superior Court judge looking at backlash, or are they supposed to? What's the job? I mean, I bring it down.
Well, they're looking at something called justice. They're looking at things like due process. And so when your side breaks those things, like when you break the Constitution, when you shatter 234 years of precedent, when you do all those things, it's not necessarily that we're mad that you're going after Trump per se. Like if there was a legitimate thing that you were doing, like we wouldn't have much to say about it, honestly. Like what would this whole show be about? We'd have nothing to talk about if it was legitimate. It's not that interesting, actually, when it is legitimate. But what people are having a backlash to is the corruption of the process. It is the weaponization of the process. That's what we're upset about, Mika, just to be clear.
Down to if you discipline a child for getting into a fight, do you go, maybe I won't discipline the child because other kids might get mad?
Yeah, but we're not children,
is
Mika.
the job to worry about backlash, or is the job to decide whether or not President Donald Trump, former President Trump, engaged in insurrection and therefore is not qualified to be on the ballot?
That's not for your illegitimate DOJ, Jack Smith, who's not even lawfully appointed, to decide.
Good morning, Mika. It's not supposed to be considered the political backlash. I mean, that's why you give federal judges and justices lifetime appointments. They're not supposed to put their finger up to the wind and see which way it's going. Now, state judges may get elected, but they too are not supposed to take into account the political consequences or the polls. And I know that some are saying, as you discussed, that this is undemocratic to take the matter away from voters. But as Charlie said, this Constitution of ours has to mean something, right? I mean, I think it's undemocratic to allow people to run for office who aren't qualified to do so. If Barack Obama...
Who gets to decide who's qualified? The Democrats do. Merrick Garland does. Joe Biden does. And Jack Smith does. Unelected prosecutors appointed, who's a private citizen, not even lawfully appointed. They just get to decide, well, we think that you committed something that disqualifies you from running. Like how that works?
Obama announced he was running for president this year. Republicans would light their
Right.
hair on fire, right? And they'd have a point. The 22nd Amendment to the Constitution says you have a maximum of 2 terms. He does not qualify to run, even though the voters may want him. And Trump, ironically, built his political brand.
That's how you know these people have no argument. It's because they just point to other qualifications in the Constitution that are clearly cut and dry, like you can't run for a 3rd term. Okay, that's not what we're talking about here. This is one political party keeping off an opponent using their discretionary rule that they just made up that happens to apply to Trump. Nobody has any questions about age 35, except I think the person in Maine or Colorado. One of them thought it was 40. I forget who. But that's how you know their argument is bad, is because they just keep going over to, well, you can't have 3rd terms. My 8-year-old can't run the country. Okay, nice argument there. So, all right, that's from MSNBC. They don't really care about what this does to the country. Now, CNN, Jake Tapper, he's pointing to these two who are on here, and he says, you know, every time Donald Trump gets indicted, every time we see a situation where he gets removed from the ballot, it seems like things continue to get better for him. Like, actually, he's going up in the polls when we go after him. What say you?
First of all, let's talk about our top story today. Trump's legal team is appealing the decision by Maine Secretary of State to try to remove him from the state's primary ballot. We've never seen anything like this. Of course, we've also never seen a president actually trying to foment violence at the Capitol to stop the counting of votes. What do you make of it?
I continue to believe that every time these states take him off the ballot, whether the primary or eventually if he becomes the nominee, try to do it for the general, that it would be appropriate for the Supreme Court to intervene, because I don't think that in this case it's good for voters to not have the chance to decide that they don't want to have Donald Trump. But I frankly think it would be politically smart for Joe Biden to come out and say,
that's also true.
Everybody who is on my side, I get it. I've said that what I think he did that day was insurrection, but I'm not afraid of this guy. And I think voters are going to choose me in the end. I think that'd be politically savvy.
Yeah, but they are afraid, though. They're petrified of the dude.
What do you think?
I agree with that point. I would love to see him say, I'm not afraid of him. I'm going to take you on. Let's do this. But I do think what's interesting about the Maine case is, remember, he was on CNN earlier today. The gentleman who brought the case is a Republican state senator who had voted for Trump, who was so horrified by January 6th that he filed this. He didn't think he should be on the ballot.
So what?
What's important about that is we are seeing in the polls, we saw in that big New York Times poll, there are increasingly voters, Republican, independents, who say a conviction would be a factor that would have them not vote for Trump. And I think, as these cases start, because,
that's getting smaller and smaller, by the way. Okay, we looked at more of this on our members only stream at Locals on the morning. You can also be a member on YouTube. We were seeing that more and more people had doubts, or having doubts about Joe Biden's legitimacy as president. The 2021 numbers are a lot different than the 2023 numbers. Everyone in 2000, I guess he's legitimate. Not so much anymore. Now, it's not a majority of the country yet, but it is trending in the right direction because people are wondering how they were able to shove this guy into the office under our noses.
The calendar didn't show the court dates in between all the court dates.
Right.
We're learning lots of new information every week. I expect that pace is going to kick up.
That's true.
Here in January. And we don't know what impact that may have on general election voters in the way that we're seeing, though, in the primary. Trump is obviously doing quite well.
Okay, so she didn't really answer the question about what should happen here. But I agree with CNN, actually, that it would be a good move for Joe Biden to come out and say something like that. This is wrong. We stand for democracy. We want democracy in America. That means everybody votes. But they don't want that at all. They don't want him on the ballot. They want him in prison. They want him convicted so the party takes him off, or so that the voters think that, he's such a criminal that they are dissuaded, or they're literally trying to keep him off the ballot now in multiple states, right? That's how they play, because they're cheaters. And this is all about election interference. James Comer confirms this. He says, look, this has been going on for a long time. Okay, the DOJ has been covering up for Joe Biden. The whistleblowers have confirmed that for us. They buried the story on the Hunter Biden laptop with the aid of ex-CIA intelligence idiots. We saw them censor people with FBI agents sending Twitter messages to Twitter to remove their stuff. All is happening right now. We're not going to wake up in 2024 in November and wonder if the feds interfered with the election. because they are doing it right now. There's court filings about it in multiple cases. Okay, the DOJ colludes with the FBI on all their cases, right? The FBI raided Trump and gave all the documents to the DOJ, and that's it. So they've already been interfering with this since August 8th, 2022.
But I'll tell you, it's good for every member of Congress, especially me, to be back home during Christmas, listening to average Americans. And I'm here in Kentucky right now. And if you ask the average Kentuckian about the Democrats and what they're trying to do right now, especially with respect to the presidential race, they'll say two things. First of all, they think it's absurd what the Democrats are trying to do in blue states in banning President Trump from the ballot. I mean, this is clearly election interference. And then the second thing that the average person on the street will say about the Democrats in this presidential race is they've got a problem with their candidate, Joe Biden. Poll after poll shows that the Americans believe his policies are bad, and that even worse for Joe Biden, he's a crook. So I think that the Democrats are trying to do everything they can in a last-ditch effort to disrupt the Republican momentum right now heading into the presidential election. I think this is another example of that. And I hate to say it, Jason, but I fear we're going to see more blue states pull stunts like this.
Yep, because that's all they've got. They are running out of other options. And so we'll see what the Supreme Court says. Of course, we're going to have a lot more to cover here. The dominoes are starting to fall, and we're going to see where this all goes. And so thank you for subscribing as we continue to cover this, my friends. And thanks for sharing this video. Thanks for sharing our channel with a friend or family member, sharing a short over there, telling them, hey, we're covering all of the actual documents, all the Trump litigation, and we're having a little fun while we're doing it. We also have our website, robertgovea.com. So if you want to read any of the documents, the PDFs are up there, robertgovea.com, links in the description. We've got our new fitness challenge at the lodge at watcherlodge.com. So it's not too late to sign up. Come and join us. We have prizes. We're going to be giving away some cool stuff in the first week of February. For those of you who want to participate, I dropped my day 3 report at watcherlodge.com. And so drop your report in there as well. And we'll check in, make sure we're getting our fitness in this new year, because we are going to be stronger and healthier than the tyrants out there across America. And so, my friends, we will be here continuing to cover this. Thank you for subscribing, and we'll see you on the next one. All right, my friends. Well, that is it for us on the day. We covered some good ground. Trump suing in Maine. We got Jack Smith confirmed illegitimate by Ed Meese in another filing. And Trump is slamming Jack's immunity brief and his final reply in the D.C. Court of Appeals. We've got oral arguments January 9th, just less than a week away, and we can't wait to get into it. But now, let's hear from you. I see some very generous super chats. Thank you for supporting our show. Thanks for supporting our work. I very much appreciate it. Wouldn't be able to do it without you. We're here. We're going over to watchingthewatchers.locals.com for our after party. Soon as we say hello to our friends, Jason Finch, welcome aboard as our newest supporter, Jason Finch, in the house. Very nice to see you. Thank you for joining us on the day. We've also got, let's pull this up here. We've got, hey, Tony, hey, Munkets, bringing in 5 new membos. Tony, hey, thanks for bringing in Carolyn H, Johnny D, Salty Old Guys joining us. JDL is here, and Frank B, all gifted membos, courtesy of Tony Hay Munkets. Thank you, Tony Hay. Very nice of you. And welcome aboard, my friends. And hey, you two membos, don't forget to grab the Telegram link, which is where the after party will be had. Navigate over to the community tab section, scroll on down, and grab the Telegram link. We got Glocky McGlock is over on Locals, says, Rob, do you think SCOTUS will rule the way they should, or rule in a way that allows CNN and Congress to say nice things about them? This SCOTUS seems kind of sketchy based on their refusal to hear arguments on the election. Glocky, I think that's a pretty good analysis, actually. Like in my heart, I hope that the Supreme Court comes out and gives 2 obvious rulings. Presidential immunity applies, double jeopardy applies, and number 3, you got to keep the candidate on the ballot. Now, how they get there, whether the 14th Amendment doesn't apply, whether it's whatever the justification is, I hope it's 3 for 3. Okay, those are actually the good rulings for America. Like, I genuinely believe that, because they're the cooling plate for partisan hacks. If we have those things, it cools all this stuff down. But I do get concerned about the Supreme Court because they are a states' rights, well, back in 2020, they deferred to the states. The states just deal with it. We're not going to get involved in it. But I think that was in the aftermath of an election, not in the run-up to an election. That's how I would disambiguate the two. So hopefully it comes off good for us. Hey, a little off topic, Rob, but Vivek ripped the media a new one, and it was awesome. I think I saw that one. And so go check out Vivek's X account. It was quite good. And I think he was blasting them on, oh, yeah, my white supremacy. Raymond Loera is here. What's up, Raymond? Says, has Jack Smith filed to prosecute Trump for his first impeachment? Trying to understand why he's going after one impeachment and not the other. Well, no. So the first impeachment was about the, my Russia collusion stuff. It was all nonsense too. And this, I don't know about statute of limitations on that one, but they really brought Jack in for the J6, right? J6 was the new thing. They needed a new hoax, essentially. So the old one burned itself out, and we've got a new hoax. And the other one just didn't, it wasn't big enough. This is a much bigger fish. Tony Hay bringing in new membos. Thank you, Tony Hay, for another 5. Bringing in Carol C, Steve D, Brad T, Deborah M is coming in, and Raul R, all here courtesy of Tony Hay Munkets. Says, hey, Rob, Glocky McGlock says, this is the face of an inside trader. This is what inside trading addiction looks like. Don't let this happen. Don't let your kids run for Congress. Not even once. Yeah, it's true. Friends don't let friends run for Congress unless you turn into Nancy. Ugh, gross. Hey, Daniel Henry, what's up, Daniel? Says, one distinction of the president, as opposed to the other two branches, is that he must be able to exercise his power without consensus. It's a feature, not a bug. Thus, he has the greatest consensus check of any to be elected. So brilliant. Yeah, Daniel, you're exactly right about this. And if the president, is the commander-in-chief power, it's like remember that great show 24 with Jack Bauer? The president, oh, I don't know what to do. Mr. President, you've got 2 minutes left. Okay, pull it. Pull it. Boom, boom, boom. Everything goes off, right? It's like, that's the point. Like, they have to have the discretion. And if you taper that discretion by saying that Jack Smith can prosecute him for something that's within the outer perimeter, then that shatters the whole thing. Any prosecutor is essentially now on par with the president, because if the president does something that they don't like, they just indict him, like Fannie does. They just don't indict him for it. And that the courts are going to be the protector of that? No. We need immunity. That's the whole point of separation of powers. And it is the right decision for the executive branch. And it's a great point, Daniel. So thank you for saying that. Without consensus. The other two branches are consensus-based. He is not, the office is not. The presidency is not. Knox here. Happy 2024, everyone. I guess 1/3 of America is ridiculous. And I think that was one of the posts that we were talking about. 1/3 of Americans do not believe Joe Biden won the 2020 election. And that number is going up. It was like 25% a year ago, and now it's much higher, which is good. That's where it should be going. Rosie's here over on Local, says, are we smart conservative, as we smart conservative Pittsburghers say? Those attacking Trump on these ridiculous charges are a bunch of jags. You know what that is short for. It's our way of calling someone a jerk in a lax way. Is that what they say up there in Pittsburghers? That's what they say up there? Shout out to our friends in Pittsburgh. I don't know. I don't have much Pittsburgh experience, but Jags. Interesting. All right, well, good to know. Yeah, Jack Smith is a piece of work, no doubt. Robbie K is a supporter. Welcome aboard, Robbie K. Good to see you. Thanks for being our latest membo. Catherine Rex says, 3 more months until we have our baby. Woo, woo. Man, we're 2/3 of the way. That means it's probably going to happen now. I think we're in the 3rd trimester. That's kind of the safe zone. So it's good to see you, Catherine. Thanks for saying that. Thanks for being a membo for 6 months. Amazing. Hey, Glocky says, Trump was found not guilty in the death of Officer Sicknick, which I'm sure. So I didn't know. Anyways, Trump has not been charged, as far as I know, with murdering Officer Sicknick. So I'm not sure what that story is, but the court rules Trump is innocent. Maybe it's a defamation case. Is it the defamation case brought by the estate of the Sicknicks? So the court ruled that he is not liable for saying things about that. I'll look into that. It's a wrongful death claim. Okay, it's a wrongful death claim. Oh gosh, is that what it was? I didn't even know this was going on. Okay, so thank you for the link. So Viantikas also shared the link with us because I can't clip that on the thing. Here's the story. Thank you for sending that, Glocky. Here, a judge dismissed a wrongful death claim against Trump for Brian Sicknick. Obviously, Brian Sicknick died of natural causes. Cassandra Fairbanks first reported this. Yeah, the DC, here it is. Yeah, DC chief medical examiner also reported he suffered 2 strokes and died of natural causes. Man, and they hate when you say that. You say that on X, man, I had some psycho lady very upset about it. You know, very upset. Yeah, I'm going to get sued. What? The Capitol Police said it. I didn't say it. The Capitol Police said it, so take it up with them. All right, so obviously Trump is not responsible for that. That's good news. I didn't even know that was going on. And I don't know why it got dismissed, but probably because it's terrible. Glocky McGlock, thanks for sending that one and for flagging that for us. We've got old drill sergeant calls it Bidenflation and Democrats. Membo for 3 months, man. Thanks for being a membo for 3 months. First month's the hardest, and so we've got a nice thing going. Nice to have you here, old drill sergeant. Glad you're here. Rosie says, who thinks Robert should have a ringtone or a t-shirt that has his woohoo sounds and words? Love it. When do I do that? Is that after we see a good motion or something? I don't even know what it sounds like. I don't know. I'll have to figure that out. Nobody wants to hear that from me, though. No doubt about it. Rosie, thank you, though. Rosie says, oh, crap, I mean a t-shirt. A ringtone or a t-shit. A t-shirt. Oh, a t-shirt. Oh, no, we definitely don't want any of those T's. Don't want any of those. Boy Wonder Robin is here. Thank you for the laugh, Rosie. That's pretty funny. Hey, Boy Wonder Robin says, can't Congress step in on this? It depends what you're asking about, but I think that Congress, if it's a constitutional issue, not really. Congress can't step in unless it's relevant, unless they want to pass a constitutional amendment or something. But I don't think so. I don't think there's any possibility that we're going to get a constitutional amendment on any of this. But hey, but it's a good question, Boy Wonder. Dapper Dave is here, says, if the court agrees with this amicus briefing, wouldn't that also make the Mar-a-Lago raid and anything seized from that raid null and void? Absolutely right, Dapper Dave. Yeah, Jack Smith is leading both of those cases. And so everything would be dismissed. All illegal prosecution, all go away. Goodbye. And you could see like how this could be recrafted. So for example, like just game this out with me politically speaking. Supreme Court comes out and says, actually Jack Smith is illegitimate and Trump cannot be prosecuted at all. Thanks for playing. Maybe they come out and he gets 3 for 3. Like, let's say it's that. Let's say Trump wins 3 for 3 or 4 for 4. Trump goes on the ballot everywhere. Trump has presidential immunity excluded. Trump also has double jeopardy protection because he was tried and acquitted in the Senate. And Trump also is immune because the cases are dismissed because Jack Smith's illegitimate. 4 for 4. Remember that? SCOTUS comes out. What do the Democrats do? Absolute bedlam. Country's over. Supreme Court needs to be packed. They would have a ton of energy, right? They would be like the victims of the Supreme Court. And they could probably ride that, for a while, right? And say that now Trump, the insurrectionist, appointed his own judges who enabled the insurrection. Like, you see how this narrative goes. And then what happens? Like, then they go into psycho mode. And the Supreme Court is illegitimate, and maybe they deny the Supreme Court's order and they keep him off the ballot anyways. Or they prosecute him anyways. They say, we're not going to, Jack Smith, we think's legitimate. He's going to continue the prosecution. You can really see how these things can start to break down pretty quickly. Stephen Mosher says, friend of Bob, Rob. Well, thank you for saying that, Stephen. Friend of Bob, Rob. Well, I'm hopefully you're saying you're friends with me, Stephen. I'm friends with you. And I really appreciate that, Dono, in the house. Thanks for saying it. Boy Wonder says, can you stop playing recordings of Liz Cheney? It hurts my ears. Same with recordings of Hillary or Nancy. Please and thank you. Actually, Boy Wonder, this is good for you. I know it's hard, but you're going to be stronger as a result of this, okay? Your ears are going to come out stronger and better for it as we make fun of these insane people. Hang in there with us. We got, hey, Boy Wonder, also Stephen Mosher says, henceforth known as Citizen Smith. I like it. Citizen Smith, Illegitimate Smith, Not So Special Counsel Smith. There's a bunch of names there. We can actually go all day with that. We got Knox is here, says Donald Trump needs to stop confiding in Liz Cheney, who appears to know his every thought. It's weird. Yeah, it's like, do they have like nightly phone calls? She's like, I just talked to Trump yesterday. He told me he's not going to leave office. Thanks for the report, Liz. Funny, Knox. Hey, we got Air Force vets in the house. Says Jack Smith will have to drop both cases if it was determined that Jack ain't Jack. This dono is for the High-Speed Wireless Communication Device Fund. Oh, so Air Force is very contributory to all of our defense funds. We started a fund today to pay down the national debt, which is now $34 trillion. So we had 51K on our locals. She did the math on this. And she said it's something like we need 10 super chats a second on the show. 10 super chats a second every day, every second for, I think, 30 years. And I think we can make a dent in the national debt. But those numbers didn't account for inflation, and they didn't account for the the total debasement of our currency. And we don't really know if America's going to be here in 30 years. So anyways, Air Force vet contributed to that fund, which I appreciate. Also contributed to the $1.2 million. We want to go get the Teddy Roosevelt, obviously his revolver, it's 1.2 million. So that's a nice fund as well. This is for the High-Speed Wireless Communication Device Fund. And did we have some bad streaming today? Do we have little hiccups in the stream? Yeah. So anyways, Air Force, very contributory. And I appreciate that. Yeah. And Jack Smith is going to have to dump both of those. Yeah, no doubt about it. And so, yeah, we're saving up to pay off the national debt. If you want to contribute, you please do so accordingly. Dolphin Fan is the man in the house, bringing in 5 new membos. We got Travis L's here, Reggie N is here, Raymond F, Eric L, and Warren M all coming in courtesy of Dolphin Fan is the man. And another one from Tony Hay, bringing in John C. Magoose is here, Angry Viking Veteran. Good to have you. Nana's in the house, Nana 1776. And Ecoms is joining us, courtesy of Tony Hay Munkets. Very nice to see you. Hey, E Harris is here. E Harris is doing a little logo. It's like a logo, but it's like an emblem, like a crest kind of a thing. It's cool. I updated the logo you downloaded the last live stream in the comments for this video. We'll check it out in the after party, E Harris. Thank you for doing it. Air Force vet says Oklahoma is the only 100% red state in America. Is that true? That's good to know. Like red Senate, red governor, red House of Representatives, red AG. A second look at Oklahoma. Brad Thorne is here. What's up, Brad? Says, hey, been a long time locals membo, but always appreciate the YouTube membo giftings, but wish I could gift it to someone I knew. Well, thanks for that, Brad. It's a nice gesture. I don't think you can do that though. Anyway, it says, happy Wednesday, watchers. Thanks, Brad, for being a membo on locals. Very grateful for that. And we try to deliver for our members. We do members only streams in the morning. We do Saturday streams. We try to deliver. So thanks, Brad. We got this one from Jennifer Newman, a membo for 4 months. Woo, we're making our way. Going up to the jackpot. Thank you, Jennifer, for being here and for being a member for 4 months. We got Boy Wonder says, can't Congress step in on the Jack Smith thing? Like they could defund him or something. It's actually a great question because there is no, like they could defund the office of the special counsel, I guess. But since Congress never actually created the office of the special counsel, can they get rid of it? It's the executive branch. They just made it up. So like certainly they could come in and defund something or defund the executive branch. But other than that, I mean, I guess they could pass legislation that says you cannot have a special counsel's office or something like that. But yeah, they're kind of operating in this gray zone. Air Force vet says, Dapper Dave beat me to the comment about the 2 Jack cases. Good job from Air Force vet. Well, they're great comments. You guys are, great minds think alike, as they say. Kosh is over here, says, hi, Rob. Good job. Thank you for saying that, Kosh. Thanks for being a locals membo, and thank you for Very nice tip over there. And another one from Dan Sterling's in the house says, no question on it, but just, hey, it's your first super chat, Dan. Woo! Welcome aboard. We're glad that you're here. And, you know, it'll go to the National Debt Fund, I'm sure. Air Force vet. Oh, okay. Air Force vet is translating. High-speed wireless communication device. There's another, that means something. It's a firearm. I guess you're right. It is a high-speed wireless communication device. I never thought about that. Yeah, you can communicate pretty aggressively, very quickly, depending on who you're talking to. I've not heard that one. That's pretty funny. Okay, so thank you for that. That's the Teddy Roosevelt Fund. All right, that's where it's going. And we're going to get that gun one day. It's going to be amazing. We got Vientikis is clipping for us hard today. Nobody You on YouTube says, love all you do. Robert, to explain the motions. Thanks for saying that, Nobody. And hey, thanks for supporting us. All the super chats, man, I really appreciate them. You guys are awesome. They are great. And we love you being here and supporting all the work we do. Let's say hello to our friends on X very briefly before we jump over to our members only after party to debrief the show at watchingthewatchers.locals.com. Who do we have in the house? Let's navigate over to X. Is anybody joining us today? We got 19 viewers on the X platform. 19 viewers. And let's see who else is chiming in today. Hey, we got Stephen Thu says, is Jack Smith guilty of impersonating a federal officer? That's a fun one. Maybe some AG could charge him for that. Yeah, I like that. That's a fun concept. Hey, Buff Chetty says, let's get it, Bobby G. Let's go. Miss Chief says, you are awesome at explaining things. It makes me feel hopeful during these hopeless times. Thanks for all you do. Well, Miss Chief, thanks for saying that. It's right back at you, honestly. I really appreciate you being here so that we can navigate these things together, because it would be difficult to do alone for me personally. So I'm really grateful for the time that we have together. Diane says, where's the link to Watching the Watchers? So it's either at watchingthewatchers.locals.com or it is watcherlodge.com for the fitness challenge and a bunch of other cool stuff coming. Jack's here. What's up, Jack? Thank you for that. Hey, George is flagging us. Share in the comment. Johnny says, how does Rob know about Secret Order 66? I saw in that movie that one time. Hey, this one is being shared from Technofog. Here's testimony from a witness. Did Jeffrey ever talk to you about Bill Clinton? He said, yeah, one time that Clinton likes them young, referring to girls. We're waiting on the Epstein stuff. You know, we've covered some of the Epstein stuff. We covered the whole Ghislaine Maxwell trial. If you missed that, if you're interested in the Epstein stuff, we went in depth on the trial. And I'm not so sure that we're going to see anything really new, interesting come out. I hope so. But I know that those were supposed to be dropping today. So we'll be reviewing those tonight and getting into it tomorrow. Here's a good puppy who's really wanting to get inside there. V says, just because there are still people that think you should get a dog, just try saying this with a straight face. You couldn't love a little puppers like this. And he's a real handsome boy. I mean, he's a real good boy right there. And I really do, want to give him some pets. Friend of Bob is a recovering addict or alcoholic. Oh, a friend of Bill W. I see what you're saying. A friend of Bill W. Yeah, that's a friend of Bob, Rob. A friend of, I think you're saying friend of Bill W. A friend of Bill is probably what maybe he was saying. I'm not so sure. Friend of Bob, I think friend of Bill is probably what you're talking about, from Fred Pedamonte, but close, pretty close. They both start with a B. Anyways, my friends, thanks for saying hello to us on the X platform. You can follow us on X. Thank you for retweeting our stuff. Thanks for following other people in the comment section, right? So follow Vientikis, follow Fred, follow our friends over here who are out there in the watcher community, like their stuff, retweet their stuff. We're trying to connect out there. That's what it's all about. We're trying to connect, stay energized, and stay engaged so that we can build an amazing community and win. Okay, we had some other final documents come in. First Amendment is saying Epstein docs are unsealed per Truth Social. All right, so we'll take a look at those. I've also got on deck, I would love to get into the Ray Epps sentencing. We're going to talk about that. Epstein docs have also come out, and we'll go look at those. It's going to be a busy week, and I'm excited about it. We're just getting warmed up. We got Rocky Water says, hey, Bob, not sure if you're looking on any ideas on new merch and stuff, but what do you think about this? Tight t-shirts printed with Judge Engerons to scale torso on the front. Oh my gosh. I can't figure out where the Watching the Watcher logo would work best. Maybe on the back? So like one of those, yeah, I know what you're talking about. Yeah, Engerons, and you could just, have the areolas out and everything. Maybe you could put the logo, like kind of squeeze it in the areolas. It's an interesting idea. We'll have to see what the community says about this. I'm not sure. Are you guys interested in sporting around Engeron's bonus torso photo? If there's enough interest, we'll do it, I guess. All right. Thank you for that concept, Rocky Water. We got this one from Radis. He says, don't waste our money on the government. You're going to need it for child support. For raising a child. When I think of child support, I think of I got to pay my ex a bunch of money for my kids because we had a nasty divorce. But I get what you're saying, Radisy. To support a child. So Technofog, huge fan of Technofog. It sounds like he's got a report out on the Epstein stuff, and he's done great work on that also. So definitely go check out him. I am subscribed to his Substack as well. Okay, so my friends, thank you very much for those amazing donos. Again, couldn't do this work without you and your support. So thanks for being here. Thanks for joining us. We are going to go over to watchingthewatchers.locals.com for our members only after party. And we would love to see you there. Come and check us out. Don't forget to check out our website. Sign up for our daily newsletter. We have all of our show reports and the PDFs available, robertgovea.com. If you want to get into the fitness challenge, we're warming up our new community platform over at watcherlodge.com with the January Fitness Challenge. We got prizes coming out at the end of the challenge. We've got scholarships that we're going to be giving away to the lodge. We've got a bunch of fun stuff I'm excited for in 2024. So come and join us, get a little bit healthy, watcherlodge.com, and join us. We got a lot of activity there. It's a lot of fun. Before we wrap it up, I want to say thanks to the mods and the meme smiths who mod down the fort for us and keep things nice and orderly. Our friends Vienticus Prime in the house. We got K Bean here, Just Cause, Playing Hooky, Ronnie Cole, our friend Zulu, Beyond Geo, Zach Nichols in the house, John Allen, I think was wrapping up early, Janek, Dog Digger, and Donut Mind Me in the house. Glad to have you, my friend. Sleepy Dog Lee, Geegum Geegum, Nathan NA10, our meme smiths, also beautifying the place for us. But that, my friends, is it for us on the day. We are going over to watchingthewatchers.locals.com for the debrief. We'll have our members only stream in the morning. We'd love to see you there. But if not, it is a new year. We got a busy new week ahead, and we are going to be back here tomorrow to get into it again. And we need to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very well. See you right back here tomorrow. Bye-bye.